Access Counselor's Office. This is Chris.
Hello, Chris. My name is Chris Throgmorton. I'm calling from LaPorte County, and I'm sort of trying to get a couple questions answered. And I also have another matter that I guess I'd sort of like to invite someone from that office to. I believe I've spoken with you before a few times.
Yeah, that's possible. So what questions can I help you with?
Um, all right. So, does the is there any way to request, I guess, a something like a statement of interest other than a a formal advisory opinion in a public records matter? Like,
Yeah,
when,
yeah. You can request. You could submit an informal inquiry, and it's non-adversarial, so there's not a complaint process. You just present whatever public access related questions you have, and then the end result is an informal opinion, which is distinguishable from an advisory opinion because you don't have the two parties.
all
So,
right,
and the document looks different, but it's basically a way to get an opinion from this office without the complaint process.
all right. So, all right, Tuesday, March 4th, um, I have a hearing basically over 21 pages of emails, I believe, in regards to my YouTube channel that the city of LaPorte is withholding from me, and I've challenged the denial of access, etc. Um, so what I'm more curious about is there's a lot of factors at play in this that to be perfectly honest, I think my judge is going to be overwhelmed with. It doesn't seem, based upon my last hearing, I think this may be his first public records denial case. Um, and sort of what I was trying to figure out is if I could invite uh, Mr. Britt or somebody from his office to sit in this hearing and then offer the public access counselors, you know, a unbiased opinion essentially on what what they think about what's going on. Because the reasoning that I'm being denied the records is it's a mess. And this is my second one with the city. And a lot of what they're claiming, they've claimed that they're claiming this investigatory records stuff, but now it's gotten into deliberative materials and some other things. Um, but long story short, they're claiming to be investigating my YouTube channel with emails between various public officials who I presume are elected. Um, and it seems like they're circumventing the open door laws and they're using the public records exemptions to do it. Um, because there's no public discussion or public meeting minutes or anything of this nature revolving around any of this. There's no public information, to fill in the gaps. Essentially, there's a lot of final action being taken in regards to whatever they're doing. You know what I mean? Based upon their claim, they're claiming deliberative materials, investigatory materials, and just a lot of stuff. The city's claimed a lot of things to withhold these documents, and it's become quite ridiculous, to be honest. And I'm essentially trying to figure out if I can get some sort of, not necessarily an amicus, kind of thing on my behalf, but basically an objective opinion on the hearing, or something to provide to the judge, that is more like an expert opinion on the Public Records Act. Does that make any sense?
Yeah, I think I'm with you.
I apologize. It's been quite confusing trying to argue against whatever they're claiming exactly. So I apologize. It sounds choppy, but
So when did you say this hearing is?
This is March 4th at 8:30 a.m. in LaPorte Superior Court 3. That would be the LaPorte City Courthouse versus the Michigan City one.
Okay. So there's a practical issue here when it comes to the public access counselor when it comes to litigation that's existing. He's actually in his enabling statutes for the office for formal complaints and informals. I mean, definitely formal complaints, but on stuff that he's limited from weighing in if there's litigation that's pending, I guess, over a public access issue. So basically, his role, the way to get his opinion or feedback and use it in litigation, essentially, the methods to do that are through the informal inquiry process or the formal complaint process and so forth. But he's precluded from weighing in when there's existing litigation.
So I couldn't subpoena him as like basically an expert on the public records law.
I mean, you can. I mean, if you can attempt to subpoena him, I guess that's probably going to go. That's going to go to the Attorney General because the AG represents state agencies on this sort of thing. Short answer is I'm not sure I'm familiar with any situation where Luke has been.
Not that I want to do that. I'm just sort of, I guess I'm entertaining all options and curious. All right, my next question would be, does the public access to public records statutes, do they apply to the clerk of courts?
So are you talking about the elected clerk at the county level?
Yes, sir.
So yes, is the short answer. You get into a little bit of legal nuance when dealing with clerks because there is a judicial set of rules that govern access to case and court records.
Right.
So the clerk is kind of a hybrid. So the clerk is going to have things in the office that are subject to APRA and APRA alone. Usually the county clerk oversees elections, so something that's not court or case related. But then when you get into case and court records, then it used to be Administrative Rule 9. Now
it's the Indiana access to public records for the courts or something. Yeah, it's January 1st of this year.
Yes. So the clerk of the courts at the county level, the elected clerk, is going to be subject to the short answer is yes, but it depends on
what the situation is.
Type of record you're dealing with, what governs disclosure.
All right, now so if let's say, for argument's sake, that these are pretty much assumed, presumptively transparent records, such as like the record of judgment orders book or like campaign finance records or something of this nature that's generally known to be public record. Would the ability to copy these with my own device apply in the clerk's office as well? Like, let's say I wanted to use my phone to just take pictures of, not the entire binder of candidates, but, certain ones, and I didn't want to go through and have the clerks make copies of every single one of these, etc. Would I be able to basically copy these with my own device in the clerk's office as well? Because that's basically what my specific question is.
Well, the Access to Public Records Act says that the agency needs to either, if somebody's seeking copies, to provide the copies or let the person
Can they force me to purchase a copy? Can they
force you to purchase a copy?
Yeah, can they force me to purchase the copy and deny me the ability to utilize my own equipment?
Well, I don't know what Rick's view on that would be. I mean, there definitely is an issue that I think could be presented under the access law. I mean, I'm not familiar with any case law or anything that susses out what defining person's own equipment. I mean, I don't know when that statute was written, what they might be referencing. Certainly not cell phones with cameras in them, but I don't know if people had means to copy things years ago. I don't know. But it does say that. So
I mean, the most logical application in 2020 would obviously be a smartphone. I mean, I have an app called Adobe Scan where I can basically just take a bunch of pictures of documents and it'll turn it into an Adobe PDF. It's 2020, so I mean, the most realistic thing would be that somebody would use their phone, maybe a camera. Photocopy, I wouldn't think in 2020 would translate into me wheeling a Xerox machine in there or something.
But I'm not sure that's what it meant originally either, but it does say that. Copy. Allow the person to make copies on the agency's equipment or on the person's own equipment. It says that within a reasonable time. Receiving a request, the public agency shall either provide the requested copies to the person making the request or allow them to make copies on the agency's equipment or their own equipment. So, again, I think, that
All right.
makes sense. I mean, there's an argument there. This hasn't really came up recently, so I think the point is well taken.
All right, now another question about something in the clerk's office, and then I'll let you go. Something that would be a large compiling of public records, such as like the record of judgments and orders book. It's a lot of public records from various cause numbers all in one book, basically. If I request to inspect this specifically, can I be denied and told basically that I need to basically provide specific documents out of this book that I want, and then I'll be provided copies, obviously at a cost?
Yeah. So the judgment book, I mean, we're talking about, I'm familiar with that reference, but I don't know how the individual clerks keep them. If we're talking about something that's like it's just a big binder with, documents in it, then I think that inspecting that is permissible. I don't know why you would have to specify that unless there's something I'm missing.
The trouble I'm going through, I think, is that there is no definition for inspection in 514.3. The one I found is in I think it's 514.2 in regards to, I want to say, like criminal history information. And that actually says like visual perusal or something. But I basically, what I'm going through with the city and county is that there is no definition for inspection in 514.3, so they just elect to deny my inspection and provide me the documents. The city's a little more, gives them to me for free.
APRA does define inspect, so
does it?
To the extent that that's helpful to you.
All right.
It's 514.32H. So
32H. Gotcha.
Yeah, 32H. Inspect includes the right to manually transcribe, make notes, abstracts, or memoranda. In the case of paper recordings, to listen and manually transcribe, duplicate, make notes, abstracts.
Gotcha. Yeah, that's what it is. It sounds a lot like copy. The definition in 514.2 for criminal, I think it's criminal intelligence information, is something along the lines of like visual perusal something or another. It focuses more on like looking. It spells it out like you're going to be looking through documents, not requesting specific ones.
Okay.
But
well,
I mean,
not sure where to go with that. Inspect and copy are both defined under APRA, so
as long as the clerk is within the jurisdiction, I can work with that. I'm to the
yeah.
end.
I mean,
As far as APRA
applying to the clerk, yes.
Yeah.
Yes.
I was actually. I mean, I had to actually.
Court rules are going to govern under for the case records, but administrative records and non-court records basically it'll be under APRA.
Gotcha. So, if they're covered under the new access to court records rules, those guidelines wouldn't facilitate an APRA complaint?
You mean if they're not following the court rules?
Yeah. I would have to take that up with the court, I presume.
Yeah, that one is. I think that one gets a little tricky because we have entertained complaints against courts and disputes over court records. So there's no real there's not really an avenue under the court rules. So basically, I think that in my mind, you can still raise a complaint over an access denial for this office, even if it's for records that are governed by those court rules, because the court rules basically say that it defers to the Access to Public Records Act, where it's silent. So.
Right, they seem to be, I mean, kind of supplemental to APRA.
Yeah, in a way. APRA sets the floor, and then the courts have power to zoom in and kind of, create their own rules, but they base it off APRA, and it says if it's silent, essentially if the court rules are silent, then it defers back to APRA.
Gotcha. All right. Yeah. Thank you very much, sir. As always, you're very, very helpful, very informative. Appreciate your time. And you have a lovely day.
You too. Thanks.
Bye.